Today I am going to discuss another aspect of divorce by the husband. As I have already discussed in my previous lecture, that a Muslim husband can repudiate the institution of the marriage or union of the marriage by pronouncing the talaq upon his wife. What is the talaq? I have already discussed. Then I told that talaq is in two forms. One is called as Talaq-ul-Sunnat and other is known as Talaq-ul-Biddat. What is Talaq-ul-Sunnat? I have already explained. And then what are the different form of the Talaq-ul-Biddat, Talaq-ul-Sunnat? That is Talaq-e-Ahsan is one of the form of Talaq-ul-Sunnat, and then Talaq-e-Ahsan another form of the Talaq-e-Sunnat that has already been discussed in detail in my previous lecture. And therefore today I would like to discuss Talaq-ul-Biddat, that is triple divorce, which is also a means to repudiate the bond of the marriage or union of the marriage. So, in addition to Talaq-ul-Ahsan and Talaq-ul-Hasan, another form of divorce recognized under Muslim law and widely practiced until the decision of the Supreme Court of India in Shaira Banu versus Union of India decided in 2017 was Talaq-ul-Biddat. This form of the divorce was recognized only among the Hanfis. Other sect did not approve this form of divorce for the purpose of repudiating the bond of the marriage or union of the marriage. And now the point is, what is Talaq-ul-Biddat and why is it called as Talaq-ul-Biddat? Any innovated practice introduced as part of the religion is said to be briefly as Biddat. Biddat here means any new practice which is not having the approval of the Holy Quran, saying of the Holy Prophet, or a classical school of thought. Every such practice which has been introduced at any later stage as a part of the religion, such innovated practice basically is called as Biddat. Biddat means new thing, introduced as part of the religious ceremony or as a part of the religion. So, the widely known Biddat form of the divorce is triple formula of the divorce. This formula of the divorce is called as Biddat, a form of the divorce, because it was an innovated practice which was introduced in the Islam during the regime of second caliph, that is Hazrat Umar. Before the Hazrat Umar, this Biddat was not, or this form of the divorce was not in practice, and therefore it became to be introduced later on during the regime of Hazrat Umar, and therefore this form of the divorce is called as Talaq-ul-Biddat. Since it neither commands the approval of the Holy Quran or traditions, nor the concurrence of the Muslim jurists of the later period, therefore this formula, that is the triple formula of the divorce, is an innovation in Sharia, hence is called as biddat form of the divorce. It may be clarified here that when any formula of the divorce is in contravention of formula of the Talaq-ul-Sunnat, every such form of the divorce will be deemed or will be regarded to be an innovation or biddat in Sharia, and triple divorce is one of the classical example of the biddat form of the divorce. Now, what is a triple divorce, or this which is also called as biddat form of the divorce? When a Muslim husband pronounces talaq 3 times during one single tuhar, or that is period of purity when wife is free from the state of menstruation, either in one sentence, I divorce you thrice, or in a separate sentences, I divorce you, I divorce you, I divorce you, or a single pronouncement is made during a tuhar, clearly indicating an intention to irrevocably dissolve the marriage by saying I divorce you irrevocably, it constitutes Talaq-ul-Biddat. So, very simple, Talaq-ul-Biddat or triple form of the divorce means the form of the divorce in which the husband pronounces the divorce upon his wife at any point of the time. She may be in the state of purity, or she may be in the course of menstruation. But when the 3 simultaneous divorces are pronounced by uttering either separately or together, then such type of repeated 3-time divorce pronounced by the husband either in the state of purity or during the period of menstruation, such formula of the divorce pronounced by the husband is known as triple divorce. It is also called as a biddat, because this formula of the divorce is not having the command or approval of the Sharia, that is the Holy Quran or saying of the Holy Prophet, as well as the concurrence of the major schools of the Muslim law, followers of the jurists of the major schools of the Muslim law, including Shia schools. Therefore, this formula of the divorce is also called as triple divorce or biddat, because it is a kind of innovated practice introduced at a particular period of the time in order to repudiate the marriage. Therefore, it is called as biddat, but it is popularly known as triple divorce. What is the triple divorce? Is defined by the celebrated authorities on Muslim law. One of the authority that has made a successful attempt to explain or define what is the triple formula of the divorce or what is a triple divorce, that is author of the Hidayah. According to the author of the Hidayah, in triple formula of the divorce, the husband repudiates by 3 simultaneous divorces in one sentence, or by repeating the sentence separately thrice in single tuhar. Thus, a husband can effect triple divorce by only one pronouncement if he makes it clear that he was pronouncing Talaq-ul-Bain, that is irrevocable divorce. Then such divorce will also be, our pronouncement will also be taken or will be considered as a tearful divorce according to the author of the Hidayah. The Talaq-ul-Biddat or tearful form of the divorce is most commonly prevalent mode of the divorce in India and also in the neighboring countries. What is the basic difference between Talaqul Sunnat, that is talaq given in the form of ahsan, and talaq given in the form of hasan, as well as the tearful divorce? In other words, we can say that what are the fundamental differences between the Talaqul Sunnat mode and Talaq-ul-Biddat mode, or a way of pronouncing the divorce. In case of Talaqul Ahsan, I have already explained that the divorce becomes irrevocable or becomes final after the period of the iddat, but which is 3 months, 3 menstrual courses. But during the iddat period, parties are at liberty to revoke it simply by cohabitation. So, from the date of pronouncement of the divorce, in Talaqul Hasan, there is a period of minimum period of the 3 months. During this period, marriage still continues despite of the fact that husband has given the divorce to his wife. Because in Ahsan formula of the divorce, a single divorce is given by the husband, one sentence is announced, that too in the period of purity, when wife is free from the menstruation and cohabitation has not taken place, and thereafter the wife is left to observe the iddat, that is the waiting period, and waiting period will be the 3 menstrual period, means there will be she will undergo iddat period for 3 months, which is prescribed period, that is the 3 months. In case the wife is pregnant, then the iddat period will extend up to the period of delivery of the child. So, during this period, parties will have the opportunity to reconcile their point of the dispute leading to the divorce, and they can revoke the divorce by reverting to each other and cohabiting with each other. And therefore, in Talaqul Ahsan, after the pronouncement of the divorce, marriage becomes finally dissolved on the expiry of the 3 months. And after 3 months, marriage stand finally dissolved. Even then, if the parties they want to reconcile and want to revert back to each other, still they can do so just by contracting the fresh marriage. Thus, it is evident from the fact that minimum period after which the talaq becomes irrevocable during the according to the Talaqul Sunnat, that is approved from the divorce, is approximately 3 months or 90 days, which is sufficient for reconsideration of the judge decision and taking further a rational decision for their own interest, in the interest of children as well as the other family members. Whereas in tearful formula or biddat form of the divorce, this opportunity is missed by the parties. According to the Hanfila, in case of the tearful divorce, it becomes effective after the 3 simultaneous pronouncement, either orally or in writing by gesture. Means in tearful divorce or in Talaq-ul-Biddat, husband pronounces with the intention to repudiate the marriage, his marriage, by pronouncing 3 simultaneous divorces in single sitting. And as soon as third pronouncement is made, third pronouncement of the divorce is made, After the third pronouncement, the marriage instantaneously becomes irrevocable and finally dissolved. It is pertinent to mention here that golden formula of the divorce as prescribed by Sharia is that every divorce should be preceded at reconciliation, consisting one person from the family of the husband and other person from the family of the wife. Means a conciliation board is constituted in case the parties are having friction on certain point that has led to the disagreement between the parties and they are intending to separate from each other. Therefore, before separating from each other, Muslim law requires that first of all both the parties should refer the name of one person and both the persons they will constituting an arbitration board. They will be called as arbiters. And the arbitration board will consist one member from the family of the husband and other from the side of the wife. And person will be the choice of the parties, that is of the husband as well as of the wife. They will make arbiters appointed by the parties will make a serious effort to resolve the point of dispute leading to separation, which is the cause of friction. The arbiters will try to address it by all means. In case arbiters fail to bring reconciliation between the parties because the relation has poisoned to such a degree that parties have gone to the point of no return and they are persisting in their intention to separate from each other due to the frictions or disagreement. Then the arbiters, consisting one member from the family of the husband and other from the family of the wife, they will recommend for the separation or for the dissolution of the marriage and then divorce will follow. But before separation, they cannot separate, but the parties cannot separate from each other just like passengers standing at the platform that they will say to each other as goodbye. Rather, if the conciliation fails and divorce is recommended, then the Muslim law prescribe a due procedure, a due form for separation. And due form of the separation as prescribed by the Muslim law is that husband will pronounce only one divorce in a period of the purity upon his wife. That is, when wife is not having the menstruation or has become free from the menstruation and there has been no cohabitation between her and the husband. During this period, golden rules of the talaq requires that husband, if the divorce has become inevitable at all, then husband should pronounce only one divorce to his wife. And after the pronouncement of that one divorce during one period of the purity, wife will still remain in the same matrimonial home and will observe that will be called as waiting period. And during this waiting period, which will be the 3 menstrual courses, she will remain in the same house, in the same matrimonial home, and will also be entitled for the maintenance and other privileges as she was entitled immediately before the pronouncement of the divorce. In case of talaq-ul-Hasan, the divorce becomes irrevocable after the period of iddat, but during the iddat period, parties are liberty to revoke it simply by cohabitation. In Talaq-ul-Hasan, it becomes irrevocable on the pronouncement for third time in the third period of Tuhar. Thus, it is evident from the fact that minimum period after which the talaq becomes irrevocable according to Talaq-ul-Sunnat, that is approved form of the divorce, is approximately 3 months or 90 days. Whereas, in triple formula of or biddat form of the divorce, according to Hanfis, it becomes effective immediately after the third simultaneous divorce pronounced either orally or in writing or by gesture by the husband. Verse 229 of Surah Al-Baqarah of the Holy Quran: during the whole married life, a husband may use the right of divorce and reunion with his wife only twice. After that, whenever he pronounces the divorce third time, the wife shall be separated from him permanently. However, during the period of the first two pronouncement of the divorces, the husband retains the right to take uh, her back as his wife. But if divorce is pronounced third time, the husband loses the right to take her back. Thus, it is also clear that even after two pronouncements of the divorces on two different occasions, the chance for retaining the wife is very much open before pronouncement of the third divorce on a separate occasion. Virtually, the third pronouncement of the divorce makes the divorce complete and irrevocable, and thereafter the right of revocation of divorce and retention of the wife comes to an end in Talaq-ul Sunnat form of the divorce. Thus, the three simultaneous divorces pronounced in one go in a single tuhar is in contravention of Holy Quran and saying of the Holy Prophet as well as classical juristic opinion. The modern Islamic jurists did not subscribe to the formula of the triple divorce because this triple formula of the divorce in fact is contrary to the spirit of the formula of the divorce as indicated in the fundamental sources of the Muslim law, that is Holy Quran as well as the saying of the Holy Prophet. Therefore, even the modern jurists of other school other than Hanfi do not agree or accept or approve the triple formula of the divorce for simple reason that there is no mention or indication of triple formula of the divorce in the pristine sources or the fundamental sources, which are Holy Quran and the saying of the Holy Prophet, read with juristic opinion of the different school except the Hanfi school. As far as the judiciary in India is concerned, it has so far, barring few exceptions, tolerated the triple divorce. There is a dichotomy in the judicial decision so far as the validity of the triple divorce is concerned. Ladies and gentlemen, in British India as well as in independent India, all the courts have declared triple pronouncement or triple formula of the divorce in one sitting as lawful, effective, that is good in law but bad in theology. The common phrase used by the courts to the effect of the validity of the triple divorce is that Talaq-ul-Biddat or triple divorce is good in law, uh, though bad in theology. It means that at one hand, Indian courts do acknowledge that triple divorce uh, is a valid form of the divorce, whereas they also acknowledge it that triple formula of the divorce is bad in theology, means there is no approval of the triple formula of the divorce either by Holy Quran or by saying of the Holy Prophet, and this has been position until 2019. In 2017, a case was decided by the Supreme Court of India that became very famous and was given wider coverage by digital as well as the print media. That case is known as Saira Banu versus Union of India and others. The court in India in Saira Banu case, it was a bench of 5 judges, and the bench by majority in the ratio of 3:2 declared that practice of the triple divorce is unconstitutional, violative of Article 21 that contains the principle of right to life and personal liberty, and also held that the practice of triple divorce is against the basic tenets of the Holy Quran. Therefore, this formula of the divorce is unconstitutional, and also held that henceforth it will be ineffective and will not have the impact of dissolving the marriage in case it is pronounced by a Muslim husband. The majority decision, speaking through Justice Rohinton Najiman, ruled in Saira Banu case on the point of validity of triple divorce. The court ruled that triple talaq was unconstitutional because it violated the right to equality and the right to live with the dignity. They also found that practice was arbitrary and did not conform to the basic tenets of the Holy Quran, tenets of the Quran. Therefore, this formula of the divorce was declared to be unconstitutional and violative of Article 14 and Article 21 of the Constitution. And it was also regarded as to the derogatory to the dignity and status of the women. The minority's judgment ruled that triple talaq was constitutional because it was an essential part of the religious practice. They urged the government to reclude the triple talaq through the legislation. The impact of this judgment led to the enactment of the Muslim Women Protection of Rights on Marriage Act 2019. They declared the practice of triple talaq void and illegal. Section 3 of the Act, said Act, says any pronouncement of talaq by a Muslim husband upon his wife by words either spoken or written or in electronic form or in any other manner whatsoever shall be void and illegal. Means now the customary form of the divorce, triple divorce, which has been in practice and was used in order to repudiate the marriage then and there on spot, which was also part of the old practice, customary practice, but it continued for centuries. This customary form of the divorce, which was derogatory to the dignity and status of the women, which was also not in consonance with the fundamental principle dealing with the divorce provided in the Holy Quran or in the saying of the Holy Prophet. This formula of the divorce was bid or was said goodbye by the Honorable Supreme Court wide judgment known as Saira Banu judgment or Saira Banu case. And pursuant to the recommendation of the bench in Saira Banu case, the government of India in 2019 brought in place a small piece of the legislation that is known as Muslim Women Protection of Rights on Marriage Act 2019. And while this piece of the legislation, this practice of the divorce, that is the triple divorce, was not only declared illegal, void and illegal. Here void and illegal expression is used here, and it means void means which is not enforceable in the court of law, which will be of no consequence. Means if the husband pronounces the 3 simultaneous divorces upon his wife, it will be of no consequence and it will not adversely impact the validity of the marriage. This is the means. So it is ineffective if the pronouncement is made in the form of the triple divorce. It is also illegal after this enactment, section 3 of Muslim Women Protection of Rights and Marriage Act 2019, that it is not only void but it is also illegal, means which is in violation of the existing rule framed by the parliament. So triple divorce is void, means ineffective, it is void ab initio, will not in any way adversely affect the nature of the marriage, sanctity of the marriage, validity of the marriage, even though 3 divorces have been pronounced by the husband upon his wife. At the same time, if the 3 divorce is given by any husband, this will be taken as violation of section 3 of the Muslim Women Protection of Rights and Divorce, which is a law duly enacted by the parliament, and for that he will be liable to be punished. And the punishment provided for the pronouncement of the 3 divorce or triple divorce as given in the act is 3 years jail. Means now after coming into force of Muslim Women Protection of Rights and Divorce Act 2019, if any Muslim husband with or without reason pronounces the triple divorce or he utters the 3 divorces at a time to his wife, this will be called as triple divorce. It will be void and will also invoke the punishment a period of 3 months. He can be sent to the jail by the court after due trial for a period of the 3 years. Therefore, it may be concluded that the subject makes it abundantly clear that formula of the triple divorce is neither warranted by the Holy Quran nor desired by the saying of the Holy Prophet, and also has not been given approval by the companions of the Holy Prophet. There is also a split opinion of the jurists regarding the triple divorce. Hanfi jurist, Maliki jurist, Shafi'i jurist, as well as Hanbali jurists, including the Shias, do not approve the formula of the triple divorce. However, Hanfi jurists, on the basis of the administrative decision of the Caliph II, which was taken by him in a given circumstance in order to address an emerging new situation, it has been held as a valid form of the divorce. And the courts in India, until the decision of the Supreme Court in Sara Bano case, hesitatingly, unwillingly accepted it as a recognized form of the divorce, but always criticized its way of pronouncement. And now finally the Supreme Court dared to declare it illegal and void, and also has on the recommendation of the Supreme Court, law has been enacted, and now it is not only void and illegal, but it is also punishable, and punishment can go up to the period of the 3 months, 3 years, if it is duly proved after the pronouncement by the wife or any his legal representative. Thank you very much.